Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law, and this will be what we're commenting on today. Tyre Sampson was a happy kid from St. Louis. He died a horrible death on a day that was supposed to be a fun day out at an amusement park.
All right, and tell me exactly what happened.
The thing went down to drop, and when they got closer to the bottom, when it hit the brakes, the guy fell right out of the seat and bam, straight through the chair and just flopped. It was the biggest smack I ever heard in my life.
Okay. All right, so we have
I seen him hit the ground.
Okay, so he fell out of the thing onto the floor?
Yeah.
Okay, are you with him now?
No, there's a whole crowd around him right now.
Okay. And was he the only one that
Yeah,
fell
he's
out?
the only one that fell, but there was 4 people on the ride.
He was 14 years old. He had traveled to the Sunshine State in the Orlando area with some friends for spring break. When the group visited Icon Park on March 24th, 2022, they had no idea what was coming. There was plenty of negligence to go around that day. Sampson was well over 300 pounds, yet he was still allowed to ride the free fall ride, despite the fact that the ride's weight limit was about 287 pounds. His belt had to be adjusted manually to make it fit him. In other words, they had to modify the ride and the seat that he was in order to let him ride. That was their first mistake. Well, actually, getting on the ride was his first mistake. But I don't want to blame the victim here. The attraction is a 430-foot tall drop tower. It takes riders all the way up to the top before leaning them forward and then dropping them down. And basically, it's a free fall. The ride spools out and you drop down fairly fast. And then as you approach the bottom, they engage the brakes and you come to a stop before you hit the ground. Well, at the point in the ride where the free fall ride was going about 75 miles per hour, Sampson's restraints failed. He fell out of the ride and he fell to his death. He was killed by crushing blunt force trauma to his chest, back, head. There really was nothing they could do for him. To be honest, I've never understood the attraction of these thrill rides. The firm that I was in Missouri, our firm was involved in the Schlitterbahn case in Kansas, where a child died in a horrifying way. And I can tell you that the rides you think are safe are really not all that safe. In the Schlitterbahn case, much as in here, the ride's Velcro straps gave way, and it launched the child out of the little canoe that they had him in, and that's when the accident happened. If you're interested in knowing what happened in that, you can Google it. I'm not going to go into it here because it's just not safe for work. Here it would appear that the modified restraints they used to fit the boy into that ride also didn't hold. But instead of only going after the park and its employees, because they did go after them, the family also went after the designer and fabricator of the ride, an Austrian company by the name of Funtime Handels.
When you look at the rides throughout the United States, name your favorite theme park, it's going to be on the list. Six Flags, Dollywood, Magical Midway, Carowinds, Cedar Point, Kings Hill, Old Town. They have rides at every one of those parks that are still operating. And they have a variety of different type of rides. It's not just the drop tower. They have the slingshot, they have the rocket, the bell, the tornado, the skydiver. At the end of this case, you're going to be presented evidence. It's in a box back there. And part of that evidence is the entire website from Funtime. We printed every page of that website so you can go through and look at all these different rides that they manufacture. The list goes on and on and on. There's too many for me to even put on the screen. And when you look at their website, they advertise. They make sure everybody knows they are the biggest and largest corporation. They talk about the slingshot being 160 kilometers per hour, 150 meters high, the Skyfall, 80 meters high, the rocket, this is 100 meters in diameter, and it's a rocket, and it shoots off in a gondola setting. This is their own website. This is what they are talking about.
It's worth noting that the family settled with the park for its negligence for an undisclosed amount about a year ago. Well, when you sue a company that is not a U.S. company, you have to use something called the Hague Convention. The Hague Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, commonly known as the Hague Service Convention, outlines the procedures for serving legal documents in lawsuits involving parties located in different member countries. Austria is a member country. When you're suing a foreign country in the United States, the convention provides a framework for ensuring that the company is properly notified of the legal action, which is a prerequisite for establishing jurisdiction. Here's a general overview of what the convention requires. Every country has something called a central authority, and that authority handles requests for service of legal documents. So, the United States State Department is the central authority for the United States, and every country has such a central authority. In the U.S., the plaintiff has to send the documents to the central authority of the country where the foreign company is located, and that authority is responsible for arranging the service of documents according to local laws. Here in the United States, when we serve process, most of the time it is done by sheriffs, the various county sheriffs all throughout the country. Then there are language requirements. The documents have to be translated into the official language of the foreign country. Now, some countries don't require translations, but pretty much every country that was not a British colony is going to require a translation. Some don't, like I said, but most do. It's crucial to check the specific requirements of the country involved. A country may have a primary language that is not their official language. For example, for a long time in the Philippines, the primary language was Tagalog, but the official language of the country was English because the Philippines had been an American protectorate. If your lawyer sends a petition to a defendant in the Czech Republic, they'll need to translate it to Czech, the official language of that republic. Similarly, they had to translate it into the official language of the Austrian government, or the Austrian language in this particular case, in Tyre Sampson's case. And then you have to complete a bunch of forms. The plaintiff must complete a service request form, which includes details about the parties and the legal action involved. The form must accompany the documents to be served, and in many cases, it too must be submitted in the language of the jurisdiction, the official language of that country. The convention also allows for different methods of service, including direct service to the central authority, service by mail if the destination country permits it, and service through diplomatic or consular agents, again subject to the foreign country's acceptance and approval. Once the documents are served, the central authority provides a certificate of service confirming that the documents have been delivered according to the convention's procedures. That certificate is crucial for providing that the foreign company was properly notified and that jurisdiction has attached. Proper service under the Hague Service Convention helps establish the U.S. court's jurisdiction over the foreign company. But jurisdiction in this country depends on more than just proper service. The company involved has to have you have to have personal jurisdiction over them and subject matter jurisdiction over them. So the company's business activities in the United States and whether or not it's fair to sue them in the United States all come into play. Still, by following the procedures outlined in the Hague Service Convention, a plaintiff ensures that the foreign company is notified of the lawsuit in a manner recognized by international law, which is critical for proceeding with legal actions in the United States courts. Now, for whatever reason, Funtime Hondells did not enter an appearance in the case, and as a result, the plaintiffs secured a default. A default could have been cured within a year by filing a motion to set aside. Usually that requires some basically non-negligent reason for why you missed service, but the family took the default and they waited until after that year was up, and then they brought their claim to court, because at that point, Funtime Handels could not do anything about the fact that they were in default. So they brought their claim to court. Many people assume that if you get a default judgment, well, you just get whatever you asked for. And that's not the case. You still have to prove up your damages. Now, in many cases, particularly contract cases, you just submit an affidavit with your contract damages and the contract, and the judge awards that amount. But in a personal injury case, you have to prove up your damages, and there are three kinds of damages you can prove: economic damages, non-economic damages, and punitive damages. And these are important things. They are distinguished in the following way. Economic loss, that's things you can replace with a checkbook. In this case, it's a child. But if the child mowed your lawn for you every summer, then an element of economic damage would be the amount that it costs to replace that child mowing your lawn, meaning a lawn service, for example. You could go to a lawn service, you could get a bid for what it would cost to maintain the yard, and that would be an element of economic damages. You see economic damages a lot more in cases where a family breadwinner, has been taken in a wrongful death case. Those are very important. And in that situation, what most plaintiffs do is they hire an economist to come up with an estimate of what that person would have made and how much they would have earned over the course of their lifetime, and then that becomes an element of economic damage. For the most part, most children do not earn income for their parents, and so the economic loss is usually pretty small, if at all. So the next element of damages is non-economic damages. And in many states, obviously not Florida here, these damages are capped. Now in Florida, they're capped for certain types of cases, but not generally for wrongful death. In Missouri, for example, in a wrongful death case with egregious facts, the limit is $750,000 for non-economic damages. In Kansas, the limit is $250,000, and it's been that way since the 1960s. Kansas has had numerous opportunities to change that cap, but it never has. Non-economic damages are very different because there's no economic model to use to gauge how much the jury should award. We had the lawn mowing incident there earlier that I used to show how you would calculate economic damages. Well, there is no economic model for non-economic damages. You can't go out and do a survey and have people sit down with you and say, if I were to break your neck at the 7th cervical vertebrae and you'd be a paraplegic from your shoulders down, how much would that be worth to you? How much would we have to pay you to make that happen? And people would probably run out of that room as fast as their feet could carry them, because nobody would willingly give you an answer on something like that. So things like that are really impossible to develop an economic model for. How much is pain worth? How much is the fear antecedent to death worth? Can you imagine what that boy felt when those straps started to give away? I mean, I can't imagine that. And then there's disability, disfigurement, death, the inability for the parents here to watch their kid graduate from high school, the inability to watch him get his letter jacket for football where he played football. All you have is the jury's estimation of what you should be paid. Whatever a jury in their exercise of good judgment believes is fair compensation for you is what you're going to get from the jury. Keep in mind, under the law, these damages are compensatory in nature. They're making up for a loss that you've suffered. The jury can't punish the wrongdoer with the economic and non-economic damages because those are compensatory. Which isn't to say that juries don't sometimes do that, but that's not what they're supposed to do. The third category of damages is punitive damages, sometimes called exemplary damages because you're making an example out of the defendant. These are for punishing the defendant for actions that were reckless and wanton and reflected a disregard for the safety of life and health. They're also subject to constitutional review. Generally, an award greater than 9 times the compensatory damages is not going to withstand appellate review. And in many cases, judges cut them back well below that because they feel sometimes that juries were just more angry than they were rational. I don't necessarily agree with that. I think whatever a jury gives should be the thing that the people get. Unfortunately, that's not the way it works. And also, in some states, punitive damages are set up for basically to provide the government with a windfall. In Missouri, if you get $10 million in punitive damages, you can keep 5, and the government gets 5. The state government gets $5 million out of your $10 million punitive judgment in order to fund basically a fund that has never been used to compensate anybody. So again, sometimes all of these damages sound a lot more vigorous than they are, I guess would be the way to put that. In this case, the jury awarded $310 million, giving $155 million to each parent. They're divorced. They could get that sum because, having defaulted, the company didn't bother to show up and contest the damages. So you're thinking, wow, how stupid, but the answer is not quite that simple. This was probably a calculated choice, as silly as that sounds. Rather than fight a case in front of a jury where the injuries are so significant, the company is probably holding its fire to mount a collateral attack on the judgment. Well, what is a collateral attack? In this case, it's an attack most likely will be based on a lack of personal jurisdiction. The company is going to allege that because the plaintiff did not strictly comply with the Hague Convention, that they never acquired jurisdiction and now they're out of time to do so because the statute of limitations on the wrongful death is probably run. Here's the thing about that, though. The company is taking a pretty big chance because if the plaintiff got a certificate of service, that's the government of that country saying you complied with our requirements. But unfortunately, for whatever reason, the company can come back and defeat the presumption of validity of that certificate of service by showing facts that they can prove that the notice was incorrect or that there were other problems with service of process. Whatever it is that they can use, they will use. And in that case, if they never acquired jurisdiction, the judgment is void. Now, it would play out this way. The company is likely holding assets in its home country, in Austria, probably has a big bank account there. I don't even know if a writ of attachment would work in Austria. I'm sure they have methods to collect judgments there, but when you bring in a foreign judgment, I'm not sure how that operates in Austria. I'm sure it'd be a fascinating video to make, but I haven't done so at this point. But the company also likely holds U.S. assets. They've got equipment in most of the theme parks in the United States. And so, because they have all of this equipment in parks all over the U.S., they likely need people here to service their equipment. They likely need equipment here that they take, vans that they take to these different parks to bring their employees. They likely have cranes and other pieces of equipment that they use to raise these rides and create these rides. They have all of that equipment, and so the plaintiff has the ability to go in and garnish that equipment or seize that equipment and sell it at a judicial auction. But here's where it gets even more complex. The plaintiff has to take the judgment to the states where they have those assets and file writs of garnishment or writs of attachment for the property. Then the company would go into court in that jurisdiction and allege that the plaintiff had not properly secured jurisdiction and that the judgment was void ab initio, or void from the get-go. That's probably another 2 to 3 year legal battle in the local court, and then add another 2 years on top of that for the appeals. Then, even if successful, the plaintiff has to sell the property and collect some portion of the money that they are owed. And likely the company does not have just one asset in the country worth $310 million, but more likely about 20 assets that, if you put them all together, might come something close to that. And if someone owes Funtime money, for example, if Funtime installed a ride in a theme park here in the United States, and if the company was going to have to pay the invoice that Funtime submitted to them for this ride that they installed, the plaintiffs could garnish that payment. And then the battle would be on there for the same thing. It's a void judgment or whatever collateral attack the company's going to make. The family has a judgment. That's nothing but a piece of paper. Turning that into cash is going to take a lot more work from the lawyers, and it's going to require a lot more than just good luck. I'll leave you with this thought. Growing up, part of my early life in Sedalia, Missouri, the Missouri State Fair is held there. And the State Fair has a midway, and the midway always had rides like the Mad Mouse, a roller coaster that screamed up and down around a metal track and went all over the place. And it was held up on these metal supports. And the metal supports had little X things that went all the way up, and it held this ride up. And it would go up about 20 or 30 feet, and they'd these little cars that would run on this little electrified track. My brother was about 2 years older than me, and I told him I was going to take my kids to the state fair to ride those rides. And he said, you know how when you buy a shelving unit or something like that you have to put together from, I don't know, IKEA or Sam's or someplace like that, and you put it together and you have parts left over? I said, yeah, that's happened. And he said, you're pretty smart. I said, yeah, I was. And he said, well, have you ever seen the people who operate those rides and who set them up? Then he went on to observe that people rarely graduate from MIT with a degree in engineering and go to work traveling the country with carnivals. He suggested that maybe, just maybe, those things were not the safest form of entertainment out there. Suffice it to say, I didn't take my kids on those rides because he had a point. A few years ago, I went to Disney World with my wife when we rode the Expedition Everest ride. Now, in that ride, you're inside a mountain and you're in the dark and you're thrown back and forth, left and right, without any warning whatsoever. In a ride that is in sunlight, you can see what's coming and brace for it. I thought sure I was going to need back surgery when I came off that thing. And that's the last time I've ever ridden a roller coaster, and I don't imagine I'll get back on one anytime soon. Here's the bottom line. There's been a race in this country to the bottom on the issue of how fast and scary a park's amusements can be. Now, if you think about it, that's just not really smart. If you value the life of your child, and indeed your own life, you have to be very careful about what rides you have. If they collect, the plaintiffs have a nice payday, but it won't bring back their son, and it won't relieve their pain of having lost their child. Sometimes parenting means saying no to rides that offer death as a bonus. I'm just saying. So that's what I have for you today. Thank you so much for being here. It's kind of a sad story, but hopefully it will have a happy ending for these people who took it to court and got a nice judgment on their son's behalf, and hopefully they will put that money to good use, funding scholarships or doing something that makes their communities better. Doing a kindness, as I often say, does make the world better, one kindness at a time. If you have the opportunity today, please do that. And then drop some comments down below. Let me know how you feel about this case. And then come on back tomorrow. Join me down here at the beach. We'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point. And although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.